And that means you either post a cash bond or you go to a surety company to get a bond. So I want to ask you some questions relevant to this.
Mhm.
What's the outstanding balance on the mortgage to the best of your understanding?
I'm sure she has the exact number. I don't have a printout of
Well,
the,
I'm assuming this isn't $1 billion loan with a
No.
$1,200 payment.
no, it's not. I think the outstanding balance for the entire year, with, they've tacked on late fees and everything, I think is approximately 30,000, or 28.
I assume your house is worth much more than that.
Yes, it is.
And do you know the interest rate on your loan?
3.5%.
Clearly didn't get that loan in the last year.
No, sir.
3.5%.
Well, we had an assumable before that. It was very nice, but the
You've
rates went
answered
down.
all my questions. I'm happy to hear additional testimony that you need to give by way of redirect.
No, it's been our position all along that there's something fishy going on, and the more we dig, the more we find. And I do think that needs to be addressed, because if Regions isn't complying with the Consumer Financial Protection Bureau, then we're going to look into that too. You see, Jeff and I are both audit hounds. We tend to dig into the facts and keep looking until we get answers to our questions.
Anything else?
No, we initially asked for the preliminary injunction in which to litigate this matter, because it was our only option available to us in the law, is to file a complaint and request a preliminary injunction, which we have every intention of complying with. Motion. Now you've dismissed Ms. Sweeney's motion to dismiss, or are we moving forward with that? Because it was my calculation that because she brought up 12B6, that does turn it into a motion for summary judgment.
Well, this is not part of your testimony, but let me just tell you, that is not the law. The law is a Rule 56 motion gets you 30 days. A Rule 12B6 motion gets you 10 days plus 5 for mailing, and it's 10 calendar days. So it's really it's 10 judicial days. So it's 14 calendar days.
Yeah.
5 for mailing. There are circumstances in which the court can decide to treat a Rule 12B6 motion as a Rule 56 motion. I don't intend to do that. I almost never do that. So your time is getting close to respond to that motion. But I looked at the calendar. It hasn't passed yet.
No, I know it hasn't.
Okay.
It was my practice to do calculations.
Why don't you have a seat? And is Mr. Zink going to testify? Why don't you guys talk about it? But while they're having that conversation, Ms. Sweeney, do you have any witness?
No, Your Honor.
Okay. Then let Mr. and Ms. Zink talk about whether Mr. Zink is going to testify, and if he's not, we'll go ahead and hear argument.
Okay. Well, you should bring that up then. Then you should go ahead and testify to that.
Sir, coming up. It sounds like you're testifying.
All right.
And before you sit, we'll have you sworn in, please. And you may swear or affirm.
Yes, sir.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Have a seat. And we'll let you do the same. Well, actually, you can do it one of two ways. She can question you if you'd prefer, or if you just want to provide me your testimony, you can do that.
The only thing that I would need to testify is the phone conversation that I had with Sarah.
Objection to hearsay before he puts any of the statements on the record.
So I don't know who Sarah is, so let's lay some foundation.
Yes,
Tell me who Sarah is.
Okay, I had called Freddie Mac. I had gotten a lovely lady named Sarah who asked me to provide the loan information in regards to what Freddie Mac had taken over the loan. Once I provided that, I did state or ask her directly, who owns the loan? Was it Regions or was it Freddie Mac? And she made the statement that it was Freddie Mac.
Let me pause for a second. Your objection's hearsay?
Yes.
It's overruled. I'm not taking it for the truth of what she said. I'm taking it for his state of mind. Go ahead.
Yes, Your Honor.
So at that point, and if you want, I recorded it. I can play it if you want. I can play the whole 45-minute phone conversation that I had with Freddie Mac. That was a phone conversation between her and Sarah.
Well, unless you've disclosed it to Ms. Sweeney, we're not going to hear it in this trial.
Okay. So once I
I'm
had
sorry. So after that conversation, you understood that Regents owned the loan?
know that Freddie Mac owns the loan and that Regions does not. And part of the problem that we've been given with correspondence going back and forth with Regions is the fact that they keep saying that they own the loan, that it's their responsibility. And we got conflicting information from Freddie Mac.
Anything else?
I think my wife has covered everything that we need to cover. She's very efficient.
Excuse me. Ms.
Bless
Sweeney,
you.
do you have questions? Thank you all.
Just very briefly, Mr. Zink, do you understand the difference between the owner of a loan, the owner of interest, and the servicer of that loan?
Okay, state that one more time.
Do you know what the difference is between the owner of a loan who provides the funds for that loan and the servicer of the loan?
Give me your definitions of those.
I think that would be a no answer to the question.
Yes, Your Honor.
Sounds like you don't understand that distinction.
Well, yes, I mean, the way that it's being presented, yeah, I need to understand your definitions of these.
Well, the servicer of a loan would be the one who collects the payments, and for the person who provided the funds for the loan does the day-to-day of that loan, and the owner was the one who just provided the funds. Do you understand the difference, how I've explained it to you?
Okay. So a bank that is the one that provides the loan itself versus somebody who is servicing the loan. That's what you're asking.
Yes.
That, yes, I do understand that part.
And you understand that Freddie Mac is the owner of your loan.
Correct.
Are you aware that Regions Bank is the servicer of that loan?
Yes.
No further questions.
All right, thank you. Anything further?
Not at this time.
All right, thank you. Go ahead and have a seat.
Okay.
Ms. Sweeney, before I hear argument, I want to get a couple pieces of information. Maybe these are in the record. Do you know what the outstanding balance of the loan is?
Yes, Your Honor.
And I'm not talking about all the stuff you add on top. I mean, just the loan.
So the unpaid principal balance?
So let's start there. And then I'm interested in accumulated interest since the last payment as well.
Yes, Your Honor. I have submitted with Exhibit N a copy of the reinstatement quote that was given to the Zinks. As of June 1st, 2025, these are accurate. The unpaid principal balance was $291,024.50.
$291.24.
50.
A little different from $28,000 to $30,000, but okay. That's the principal balance?
That is the unpaid principal.
And then do you have a calculation of accrued interest since then?
Yes, to June 1st, 2025, it is $11,397.44.
Your view is that the loan was in default as of June 2025, or do you mean June 2026?
This is accrued interest from the reinstatement quote that was given from June 1st, 2025 to present.
To present,
Correct.
sorry. So interest
Accrued and, yeah.
from
accrued
June
interest.
2025 to present.
Correct.
Thank you. I thought you said interest as of June 2025. Now it makes sense to me. What's the number again?
11,397 and 44 cents.
And do you know what the monthly payments are?
Yes, Your Honor. This was submitted with the complaint exhibit H. The monthly payment was $18.24 and 88 cents.
1824.88.
Yes.
Thank you. I appreciate those numbers.
Yes, Your
All
Honor.
right. Let's hear closing arguments, Ms. Zink.
First, I'd like to point out that the payment structure that she provided is that we didn't make a payment in June. So that interest is not going to be accurate if we did make a payment in June of 2025.
Okay.
Also, that payment amount includes insurance as well as taxes. So that wouldn't be the principal and interest on the loan.
And I should have asked you this while you were testifying. Have you not been paying your insurance and your taxes
I have.
separately?
Mhm.
Got it. Thank you. All right, let's hear closing arguments.
Okay, Your Honor, this case comes from the position that Regions hasn't complied with the contract or the information that we have requested from them to establish the validity that they are the accurate servicer on the note. That's where this all started. And they continue to not comply with any of our requests to confirm that validity. And they escalated this by implementing a trustee sale when we could have resolved this issue months ago. And we were trying to do that. That's pretty much the only argument I have at this point after all the testimony that I've given. With that being said, as we were just peeling back the layers of Region's position as the servicer, we were discovering all these inconsistencies and felt that that should be addressed. And it can only be addressed in a court of law. If they're not going to comply with their own regulations or consumer protection regulations, then how does it make sense that we allow them to foreclose on our home, depriving us of our house because they haven't complied with these regulations?
Is there a document in the record that'll tell me how much of that monthly payment is principal and interest and how much is insurance and taxes?
Yes, Your Honor.
All right, I'm talking to Ms. Zink.
Oh, I apologize.
I don't think I have anything. I have anything in the record that identifies those numbers. They haven't provided that.
Well, you would have that information. I mean, you get your monthly statements.
Yeah,
But if it's not if you don't have it in the record.
I do not have it handy. Sorry.
Yes, Your Honor, it's Exhibit M, the loan transaction history.
Let's look at Exhibit M. Well, let me change its direction before I look at it because it's.
Oh, sorry. Yes, it is. It's the payment. It's the payment history. Which one is M?
Yeah, I don't know that answers the question, but well, I guess it does. Are you willing to accept this as accurate, Ms. Zink, or do you think that I'm looking at the wrong thing?
No, I'm getting there.
Yeah. Here's my rotate button.
I thought I had. Oh, I don't have it. Oh,
Principal, interest.
thank you.
Yeah.
It's got three. It's got principal, interest, and escrow.
Correct.
Okay.
Okay, yes, this would be the accurate accounting. I thought we had copies of this in our exhibits. I was pretty sure that we did, but.
It may be an exhibit to your complaint, so.
Mhm.
All right, then let's hear from Ms. Sweeney. Argument, please.
Yes, Your Honor. I believe I've submitted thank you, a lot of defense's arguments with our filed objection to the preliminary injunction. So I won't rehash a lot of what was stated. But whatever disputes the plaintiff ultimately has with Regions Bank, none of it amounts to being sufficient to stop the foreclosure sale. The plaintiffs have admitted on the record that they have purposely not made a mortgage payment in over 1 year. And now that they're claiming that this foreclosure sale should be stopped. They could have made payments in the interim. They could have initiated this litigation and had been suing Regions while still making their payments. None of what is in the complaint is sufficient to prevent this foreclosure sale from happening. They could have kept their loan current and also sought this monetary relief and had this battle with Regions Bank. And part of issuing a temporary restraining order is being able to show irreparable harm. When there is adequate remedies available at law, then a preliminary injunction is inappropriate. There are adequate remedies at law for all the claims that are in the plaintiff's complaint, and that would be to sue Regions and to get monetary relief for their claims.
Well, it's not an adequate remedy to losing your house, right? I mean, property is unique. Real property is unique.
Not under Arizona case law, Your Honor. In the objection.
Why do we specifically perform real estate contracts?
Your Honor, in the objection that I filed against the preliminary injunction, it's Arizona Supreme Court case law as well as case law from the Arizona District Court that foreclosure of a regular property that's not an ancient house or something like Graceland that doesn't rise to irreparable harm. It might be, and I believe there's a quote from a case within that motion, that it may be disruptive of the plaintiff's lives, but that doesn't mean that it rises to irreparable harm just because it's real property. It's not sufficiently unique unless there's something more with the property. And there is an adequate remedy at law here that for all of their claims, they can go and pursue this against mortgage. There is no irreparable harm.
May I rebut that?
When she's finished, you may.
Mhm.
It's hard to argue the success of likelihood on the merits when the lender has not been made a defendant in this case. Certainly all the claims against the foreclosure trustee, there's nowhere in the complaint that there is alleged a breach of the trustee's fiduciary duty. Mostly that is lack of notice. The defendants have admitted that they have notice of the trustee sale. So as of right now, there can be no success on the likelihood of the merits until the lender is brought into this litigation. Even with that, all of their claims.
You say the lender, do you mean Freddie Mac or do you mean Regions?
Both in tandem, Regions Bank generally. I represent Regions Bank. I do not represent Freddie Mac.
Okay.
Sorry, the terminology we use, lender. And since Regions Bank has been brought into this litigation, there can really be no real success on the likelihood of the merits. If they have issues with the accounting, it's hard to say that there is a likelihood of success on the merits until they can point to. They have testified that they don't believe, they have no real reason to doubt that Regions is not who they say they are, that they don't have authority to foreclose the note. They had one bad check reversal in July of 2025, did not try to remedy it in any other manner, and then stopped furnishing payments because they did not believe.
Where's the evidence that that was a bad check?
It's in that same exhibit, exhibit
None of the
M.
exhibits are admitted in evidence. Nobody moved in any exhibits.
I apologize, Your Honor. It is within Exhibit M. That July 14th payment was reversed as a bad check reversal.
By bad check, you mean insufficient funds?
The only information I have is from the document that said it's a bad check reversal.
Okay.
So after that bad check reversal, now that they're claiming that there's something fraudulent going on with Regions, that their payments are not going where they say they are. This is all speculatory and does not go to any real likelihood of success on the merits. Going to the other prongs of a TRO, the balance of the hardships, because their claims for relief are so speculative, it's hard to say that the balance would favor the plaintiff. So it would instead favor the lender, who does have the authority to foreclose and who does not have to prove their authority before pursuing foreclosure under Hogan v. Washington.
What's the hardship to the lender of a delay?
And not being able to, incurring attorney's fees, incurring fees to cancel this foreclosure sale, to restart as they would have to do so if the
Things
injunction.
that can be compensated for.
Yes, Your Honor, but they're still prevented from going forward with their contractual right to do something. They're being prevented from doing that. And it's still prejudice against the lender in that way. I would argue that none of the prongs of issuing a preliminary injunction are available here, and I would request that the court deny that request.
What's the bond that you're requesting if I do grant a preliminary injunction, or have you not really done that math?
Your Honor, I would request a bond of $1975 that amounts to the amount of the cost to, if you were to issue a preliminary injunction, Regions Bank would have to restart the foreclosure sale. The amount,
1,975?
yes, Your Honor, the amount to do so would be $1875. And to postpone the sale would be $100. So we would request $1975 to cover both of those options.
Thank you. And I forgot to ask you, what's the current date of the trustee sale? I can't remember
It's the
what we
20th.
did
It is the 20th
of
August.
August. Oh, that's right. We discussed this at the prior hearing. Thank you. Anything else before we turn back to the Zinks?
No, Your Honor.
All right, ma'am, last word.
So much. Um, First, as you know, we just found out that it was a bad check. That was never disclosed to us.
I will tell you, I'm not considering that as evidence because I didn't have
Okay.
anybody testify about it.
I am just clarifying. Also, how has Regions been damaged in any way? Yet they want to take our home that we've owned for 13 years in that neighborhood. I'm also the president of the HOA. So that's how involved in our community that we both are. So there is hardship that would be imposed on us. We have tried to be very reasonable through this whole process. We're just asking for clarification, which Regions has denied providing us any of that information. And as I stated in my testimony, we just kept digging and discovered more inconsistencies with their procedures, including not notifying us that they had that the servicing had been assigned to them when they were supposed to. And I would also argue that doing the substitution of trustee is also an assignment to another entity to secure the trustee sale. All of those things I had to go digging myself for on the county recorder's office, which as a party to the deed of trust, we should have been given that information. So I do request that you grant the preliminary injunction while we go through and litigate this process. I do not agree with defense that our complaint doesn't rise when we have included a breach of contract provision in our complaint. And so that is where we will address paragraphs 2 and 3. And that is the form of payments that the servicer is supposed to comply with.
Right. Anything else?
Just waiting for you to make a determination. Thank you, sir.
So my normal practice is to take these under advisement, and I'm going to do that. I'm going to issue a written decision. But because the trustee sale is so close, I'm going to tell you right now that I'm granting a preliminary injunction, at least as to the August 20 trustee sale, conditioned on the posting of a bond in the amount of $1,975. The rest of my ruling, I haven't decided, and I'll decide it in writing. That includes when I would allow the trustee sale to be reset and under what conditions. I need to go through some things before I'm ready to make that decision. But so you all know to plan, I am going to enjoin the August 20 trustee sale. conditioned on the posting of a bond by plaintiffs in the amount of $1,975.
I have one question for you. So if we make the, if my husband and I make the determination that we just want to pay off the mortgage entirely, can we request that the case is preserved?
I don't know the answer to that. That's a legal question. I don't know what paying off the loan does to legal claims against either the trustee or the lender. And so I don't know what to do with that.
Okay, I just wanted to throw that out there.
Yeah. I would ask you to consider, if you pay off the loan and the trustee sale goes away, what your damages would be for those things, and whether it's worth bringing a lawsuit for the damages you might have. But you may have other ideas about what your damages are and what your causes of action are as well. I'll let you figure that out.
Okay, thank you.
I think we've covered it today. I'll get you a written decision as promptly as I can. Is there anything else we need to do?
Nothing from defense.
Thank you very much.
Nothing from us.
Be in
Thank you.
recess.